Good morning. Thank you so much for joining us today for our Wednesday webinar on Social Security disability for Down syndrome. My name is Caitlin Wildoner. I am the founding attorney of Beacon Disability PLLC, which is a law firm based in Florida, where we help clients with their disability claims at the federal level. And we'll get into that more in just a moment. Before we get started, I do want to make sure that I mention that today's webinar is meant for informational purposes. It is not legal advice. I also, to that end, can't answer questions really that come in through the chat on the live or are left in the comments on the replay. And the reason for that is not because I don't want to help, because I do, but the reason for that is because I often need more information than what's provided. So it's really hard to be able to give you an answer when I'm getting just a part of the story, and when I typically need additional information in order to give a solid answer. And even still, with additional information, there may not necessarily be a solid answer. But the best way to find out is we will go ahead and drop in the chat now, and on the replay down below, there will be a link to schedule a call with us. At the end of the webinar, there will also be our phone number, I believe our email address, and you can always feel free to use one of those three methods to get in touch with us. And that way, if you do have questions, please do feel free to ask, but through one of those three venues, so that way we can be sure that we are being able to get all of the information that we may need to give you a solid answer. So with all of that being said, let's go ahead and get started. Here's our roadmap for today. We are first going to talk about some Social Security disability basics, and then some Social Security guidance. And then we're going to talk about two listings. One is listing 110.06, and the other is listing 10.06. And as you can see, the listings are the same. The only difference is one is 100 and the other is just 10. And the reason for that is the listing that's 110.06 is the listing for children, whereas the listing for 10.06 is the listing for adults. So Social Security does separate out the child listings and the adult listings, and you'll be able to see there, that they are going to be quite similar. We'll also talk about some considerations, and then finally, how an attorney may be able to help you with your Social Security disability claim. As I said before, my name is Caitlin Wildoner. I'm the founding attorney at Beacon Disability PLLC, where we exclusively practice federal administrative law and help clients with their SSDI and SSI claims at the agency level throughout the United States. If for some reason we are unable to help you, we do try to put you in touch with somebody who can. So please do feel free to reach out. Use the link in the chat on the live to schedule a call, the link down below to schedule a call. Call us directly, send us an email. As I've said, we are very happy to help in any way that we can, but unfortunately, answering questions on the live or in the comments is just really difficult to do, because it's hard to make sure that we're getting all of the information to give you a good answer based on your situation. Okay, here are Social Security disability basics. There are two different Social Security disability programs. Both programs are going to require that you be disabled and unable to work for a period of at least 12 months as an adult. As a child, they are a little bit different, and we'll talk about that in a minute, I believe. But they do both require that you are going to be disabled for at least 12 months. That means that if your disability lasts less than 12 months, which we don't typically see with Down syndrome cases, but is instead typical in cases with back pain, shoulder pain, knee pain, things like that, where it may only last 7 to 8 months between the injury and then the total recovery time. So like I said, the time is not typically a problem in Down syndrome cases, because it's not something that you're diagnosed with that can then go away. The difference in the two programs with respect to adults is with SSDI, an individual has to have worked and paid into the system long enough. And with SSI, there are income and asset restrictions. For children can qualify for SSDI benefits if their mom or dad is deceased, retired, or disabled. That child may be able to receive benefits riding on the parent's SSDI benefit. So that's sometimes, even without that work history requirement, If you are a child of a parent who is deceased, retired, or disabled, you may be able to basically ride on their SSDI benefit and get an additional benefit. With SSI with children, there are still income and asset restrictions. That is going to be for the family. They do look at the household size. And that's why, with sufficient work credits for SSDI, we typically say that you have to have worked 5 of the last 10 years in order to qualify. With SSI, it's a little bit more of a gray area because there are income and asset restrictions. It does depend on household size. The assets, you cannot have more than $2,000 in assets if you are single and more than $3,000 in assets if you are married. It does not include one home or one car, but by and large, everything above that. So there are specific brochures from Social Security that you can take a look at that will show you go through those income restrictions. We don't cover those on the webinar, but that information is absolutely out there. And you can also contact Social Security directly if you are not sure. Unfortunately, particularly with children cases as it relates to Down syndrome, what I see time and time again from when the child is born until the child turns 18 is mom and dad have either too much income or too many assets. And so they don't tend to qualify for Social Security benefits as a minor child because maybe mom and dad are both working, or one is working and one is stay at home, but neither are deceased, retired, or disabled. And the income and assets exceed the threshold allowed for SSI. So unfortunately, a lot of children with Down syndrome, the ability to reach into Social Security benefits is not there. However, upon turning 18, it's something to look into. Here is the 5-step evaluation process when you submit an application for disability benefits. The very first thing that's going to be done, even before the 5-step, is to make sure that the individual would qualify under that extra prong of SSDI or SSI. The extra prong being SSDI, that there's a sufficient number of work credits, and SSI being that the income and assets are below the necessary thresholds. So that's step 0. Once you meet that step 0, the case evaluation will go to step 1 of the 5-step evaluation process. And that is Social Security is first going to look to see, are you currently engaging in substantial gainful activity? For 2023, that means, are you working 20 hours a week or more? Or are you earning more than $1,470 a month in gross earnings? So are you earning more than $1,470 a month in gross earnings before taxes, insurance, any of that comes out? If you are, or you are working more than 20 hours a week, the evaluation will stop there and Social Security will say, you cannot be found disabled under our rules. If you are not engaging in substantial gainful activity, the analysis moves to step 2, where they begin to look at your medical records. And they look to see, do you have at least one severe medically determinable impairment? If you don't have at least one severe medically determinable impairment, again, the analysis will stop there. The agency will say, you cannot be found disabled under our rules because you don't have at least one severe impairment that impacts your ability to function on a daily basis. As long as you have at least one severe medically determinable impairment, it'll move to step 3, where they will look at the listings. We will talk about the Down syndrome listings in just a moment, where you will see what will be needed in the medical record to meet or equal the listing. If you don't meet or equal the listing, the analysis continues. If you do meet or equal the listing, and like I said, we'll talk about the Down syndrome 2 listings in just a moment, then that's fine. Then your case is stop there and you will be approved at step 3. Again, if you don't meet or equal that listing, it moves to step 4, where they create a residual functional capacity and see excuse me, and they will see, can an individual with this residual functional capacity go back to do your past work if you have some? If you don't have any past work, or if you can not go back to your past work, it goes to step 5, where they will say, okay, can you engage in any other work? If you can either engage in your past relevant work or any other work based on your age, education, RFC, you will be found not disabled. If you cannot engage in your past work or any other work, then you will be found to be disabled by the Social Security Administration. Typically, Down syndrome cases will stop at step 3. but it is possible for them to go to step 4 and step 5. Here are some considerations to make. Adults can still qualify for Social Security benefits if their residual functional capacity is less than what their past work would require, and it prohibits you from engaging in substantial gainful activity on a regular and ongoing basis, okay? For children, if they don't meet or equal that listing, then they're not going to look at the RFC, but instead, they can still qualify for Social Security disability benefits if they have a marked limitation in 2 of the 6 domains, and I don't have the domains here, or a severe limitation in 1 of the 6 domains. And what those 6 domains are is they are basically an analysis of what children are capable of doing. So they're going to look at like their ability to acquire information, acquire and use information, their ability to interact with others, their health and physical well-being overall, their ability to move and manipulate objects. Things like that. I believe that's 4 of the 6. Maintain attention and concentration is another one. And the 6th one is escaping me at the moment. But those 6 domains, they can easily be found. If you have questions about those domains, feel free to send us an email at the end and I can send them over to you. I apologize about having the brain lapse. SSI benefits are only going to be payable to children and adults who have limited resources, as I've mentioned before. SSDI benefits are only payable to adults who have earned a sufficient number of work credits and children whose parents are deceased, retired, or disabled. Okay, looking here at the adult listing for non-mosaic Down syndrome. Here are what they are going to be looking for. As you can see, there are 3 different avenues towards the listing. One is going to be a lab report that is signed by a physician, or a lab report and a statement that's signed by a physician. If the lab report is not signed by the physician, then the statement will need to be signed. And that statement just has to make a statement that you do have Down syndrome. Alternatively, a physician's report that is consistent with the lab analysis, and you also have the distinctive facial or other physical features of Down syndrome. That's the second avenue. And then the third avenue is, again, a physician's report stating that you do have Down syndrome with those distinctive facial features or other physical features, and evidence that demonstrates that you function at a level that's consistent with non-mosaic Down syndrome. So 2 of the 3 will need a lab report. Really, all 3 can use a statement by a physician, and that is that's pretty common. So it's these listings are still difficult to meet, but non-mosaic Down syndrome is one where if you have the diagnosis and kind of the supporting lab work or distinctive features, that can be enough to get it approved. And that's why I was saying step 3, most Down syndrome cases are able to be approved at step 3, because if you have been diagnosed with non-mosaic Down syndrome, this is pretty common to be found in your medical records. Looking at 110.06, it is the exact same. So it's just, instead of stating that you have all of this, it's stating that the child has this. And so again, it's going to be the physician statement, lab work, analysis, things like that, as well as, again, the physician statement that says that, yes, been diagnosed with non-mosaic Down syndrome, and or you have the distinctive facial or other features. Here are my 6 domains. So acquiring and using information, attending and completing tasks, interacting and relating with others, moving about and manipulating objects, caring for yourself is the one that I forgot, and then health and physical well-being. So as I mentioned before, for children, if they don't meet this listing here, what they can do is they can still qualify for Social Security benefits. Instead of an RFC, Social Security is going to look to see, does the child have marked limitation in 2 of those 6 domains, or extreme severe limitation in 1 of the 6 domains? And again, here are those 6 domains. So for children, After step 3, if the child does not meet that listing, then this is what Social Security is going to be looking at, is they're going to be looking at the domains and the areas of functioning and what limitations the child may have in these areas. If the child meets the listing, the domains of functioning are irrelevant because they meet the listing. Here is kind of what Social Security considers to be marked and extreme functioning when it comes to children. Because it's not terribly relevant when it comes to Down syndrome cases, I will leave it up here for just a minute to look at. As you'll see, the marked limitation is when your impairment interferes seriously with your ability to independently initiate, sustain, or complete activities. Extreme is when it very seriously interferes with your ability to independently initiate, sustain, and complete activities. So as you can see, there's a slight difference between the two, and go ahead, those are the differences. Here are considerations to make in Social Security cases. Medical records are key. Okay, as you saw with the listing, lab report, analysis, doctor's note. That's what's needed. The issue in adult Social Security disability cases, if you don't have the records needed to meet the listing, is not just can you go back to your past work, but are there other jobs that exist in the national economy that you can do? For children, when they don't meet the listing, the issue is not obviously about work because children don't work, but the issue is how does the child function every day in all settings when compared to children the same age who don't have impairments. So that's kind of the difference between the two. That's the overarching theme. Again, as it relates to Down syndrome, typically cases that involve a Down syndrome diagnosis are able to be approved at step 3, because as you can see, it's one of those where the medical records really kind of lay it out there. However, functional capacity can also be relevant, and objective medical records will be important. Finally, here's how an attorney can help you. This is not a comprehensive list, but it kind of covers some of the things that we do most often. One of those common things that we do is we provide guidance on what correspondence from Social Security actually means. So oftentimes we've got clients getting letters and they're like, I don't know what to do with this. What does this mean? What are they asking for? We help you with that. If you are already working with us or you reach out to us within a the time frame necessary, we can file an appeal for your denial. We can review your medical records and your case file. We can discuss what additional records might be helpful in your case. Again, specific to Down syndrome, it's going to come down to that lab report and a physician statement. If the physician can't do that statement, we're going to have trouble. We can review your documents for accuracy and completeness. If you filed for disability before or you're currently filing for disability, you likely know that Social Security will send questionnaires to you to get more information about your activities of daily living, where your limitations are, things like that. We don't fill those forms out for you because we aren't in your shoes. But what we can do is we can provide guidance on what Social Security is looking for, and then help review them with you after they are done to see, okay, are you being upfront, forthright, and honest in your responses, or did you overstate or sugarcoat your limitations? We work with you to provide relevant updates to and from Social Security throughout your claim. We prepare you for a hearing before an administrative law judge if it gets to that level, as well as question you and any witnesses during your hearing. I want to make a quick mention that when I say we question you and any witnesses, that does not necessarily mean your witnesses as your family members, friends, coworkers, doctors, things like that. That's not really how Social Security claims tend to work. If you're a client of ours, you know how we handle our witness testimony. And if you are a client of ours and you don't yet know how we handle our witness testimony and you're at the hearing level and you have questions, feel free to reach out because that's something that, I would like to chat with you about. Like I said, this is not a complete list of what we can do to help, but it does provide some insight into what an attorney can help with. As promised, here's our contact information. feel free to give us a call, send us an email. We'll go ahead and drop on the live into the chat the link to schedule a call again. That way it's there. On the replay, that link will be down below. Please feel free to schedule a call. Just put in the notes, what it is that you're calling about, especially if it's SSI as it relates to Down syndrome. That will help us to know what we are going to expect to talk about when we give you a call at the scheduled time. So thank you so much for joining us today, and have a wonderful day.